Webcast. Bonjour à la délégation de Hong Kong, Chine, région administrative spéciale. Il s'agit de la 3893e séance de la 135e session. Nous allons poursuivre le dialogue constructif avec Hong Kong, Chine. Salutations à la...
As agreed yesterday, we will be giving 10 minutes this morning, 10 minutes, to the delegation to complete its responses from the questions raised by my colleagues yesterday. I would like to remind the delegation that this committee has carefully read all the documentation, carefully read the responses and the report and the responses. And so I would kindly ask the delegation to perhaps focus more on directly answering questions that were raised yesterday. The committee is aware of the legislation, the existing legislation, so any further information is welcome. As the delegation knows, there is also the possibility to submit statistical or other information in writing after this dialogue. So I will immediately give the floor to the head of the delegation, Mr. Chan Kuo Kwai, for the 10 minutes to conclude the responses of yesterday. Over to you, sir.
Please excuse us for overrun yesterday. We just tried to give as much as possible information to members so as to clear the doubts and concerns. Anyway, thanks again for giving us the extra time. So let's start with Mr. Mui, please.
Thank you, Madam Chair. Thank you, Mr. Zhang. I would like to continue with my replies and comments in relation to the question on the emergency regulations ordinance. Briefly, I have a few points to reply. Firstly, the powers under the emergency regulation ordinance of the Hong Kong SAR can only be exercised in accordance with the Hong Kong Bill of Rights Ordinance. The ordinance includes a section, which is Section 5, which actually implements Article 4 of the ICCPR. Article 4, of course, we all know that it concerns the safeguards concerning the derogation in time of public emergency. So under the ERO, under the ordinance, the Chief Executive in Council may consider to issue regulation if the occasion faces the Chief Executive in Council constitute emergency or public danger. But the term of emergency under the ordinance may or may not amount to the level of situation constituting the Section 5 or Article 4 situation. If it is a very serious situation of emergency, then it may trigger the protection under Article 4 of ICCPR. Of course, under this situation, the regulation to be made under the ERO have to be compatible with the requirement of Article 4. And if the situation is not so serious, then the normal requirement of proportionality will apply. This requirement has been actually confirmed by a recent case decided by the Hong Kong Court of Final Appeal concerning the question of validity of the regulation on prohibition of face covering regulation. In that case, our Court of Final Appeal has confirmed that the regulation is constitutional and it passed the proportionality test. Lastly, I would like to quickly respond to a question raised by Mr. Furuya yesterday concerning the measures taken by Hong Kong to tackle the COVID pandemic. Actually, the measures were not made under the Emergency Regulations Ordinance. They were made under another ordinance in Hong Kong, which is the Prevention and Control of Disease Ordinance, which provides for the legal basis for the measures taken by the Hong Kong government to tackle the COVID-19 pandemic. Thank you, Madam Chair. I would like to pass the floor to my colleague, Ms. Kathy Lee.
Thank you, Mr. Mui. Madam Chairperson, first of all, I would like to explain the HKSAR government's position on the establishment of an independent human rights institution in response to Mr. Buchan's comments yesterday. Human rights are fully protected by law in Hong Kong, the Constitution of the People's Republic of China, and the basic law of the HKSAR provide constitutional guarantee for fundamental rights and freedoms. Hong Kong also has an existing institutional framework which helps promote and safeguards various rights, including the statutory organizations of the Equal Opportunities Commission, EOC in short, the Office of the Privacy Commissioner for Personal Data, and the Ombudsman, as well as legal aid services. The HKSAR government's performance in promoting and safeguarding human rights is open to public scrutiny through regular reports to the United Nations and under the scrutiny of the Legislative Council, the media, and various non-governmental human rights organizations. The HKSAR government maintains the view that the existing mechanism has worked well and that there's no need to set up an additional human rights institution which would duplicate the functions and work of the existing mechanism. Regarding the EOC compliance with the Paris Principles, I would like to point out that the EOC is not a national institution that falls under the scope of the Paris Principles. The anti-discrimination ordinances only provide the EOC the power to investigate specific issues relating to discrimination and harassment. Nonetheless, the EOC largely follows the Paris Principles in terms of independence, autonomy, pluralism, powers of investigation, resources, and powers to take legal action. We also note members' remarks on racial discrimination on the part of the HKSAR government, including the law enforcement agencies. I would like to underline that under HKSAR's legal framework, public bodies have always been prohibited from practicing racial discrimination. The Hong Kong Bill of Rights Ordinance prohibits the HKSAR government and public authorities from engaging in practices that would entail any form of discrimination, including discrimination on the ground of race. On anti-discrimination front, the government reviews existing anti-discrimination ordinances to ensure that they meet changing social needs and will introduce legislative proposals to address social mischiefs as necessary in the light of local circumstances. For example, the Discrimination Legislation Miscellaneous Amendments Ordinance 2020 and the Sex Discrimination Amendment Ordinance 2021 were passed by the Legislative Council in June 2020 and March 2021, respectively, to enhance protection from discrimination and harassment under the 4 anti-discrimination ordinances, i.e., the Sex Discrimination Ordinance, Disability Discrimination Ordinance, Family Status Discrimination Ordinance, and Race Discrimination Ordinance. Among others, the Sex Discrimination Ordinance has been amended to strengthen legal protection for breastfeeding women, whereby discrimination and harassment on the ground of breastfeeding in various prescribed areas, such as employment, education, provision of goods, facilities, or services, etc., are prohibited with effect from the 19th of June, 2021. In response to Ms. Sarsin's comments on anti-discrimination legislation on the grounds of sexual orientation and gender identity, the Hong Kong society is divided as to whether legislation should be introduced to prohibit discrimination on the grounds of sexual orientation and gender identity. On the one hand, there are views that the government should introduce legislation to safeguard equal opportunities for sexual minorities. On the other hand, there are views that the introduction of legislation will have impacts on traditional family values and freedom of religious belief. Given the complicated and controversial nature of this issue, we must handle it with caution. In response to members' question about the handling of transgender persons in custody, currently, the Correctional Services Department arranges transgender persons in custody to serve their sentence in the transgender unit to protect them from harassment by other persons in custody and meet their special needs. Professionals there will provide them with proper health care and necessary treatments. Generally, persons in custody in the transgender unit are in normal association and can interact with other persons in custody. We would like to emphasize that the arrangements mentioned are different from separate confinement, which is a form of punishment for offenses against prison discipline. May I pass the mic to Mr. Raymond Holmes?
Thank you, Kathy. Madam Chairperson, I would like to respond to the question of Mr. Gomez on domestic violence. The Hong Kong SAR government takes a serious view on combating domestic violence. We have adopted a multidisciplinary model and a three-pronged approach, comprising preventive, supportive, and specialized services to tackle domestic violence and to support the victims and their families. The Hong Kong police takes up enforcement against cases that are criminal in nature, such as wounding, serious assault, and criminal damage. Depending on the circumstances of individual cases, the protection and support may include the provision of shelter, medical and psychological services, counseling, childcare, financial and housing assistance. During January 2010 to May this year, the Court of the Hong Kong SAR granted 426 injunctions under the Domestic and Cohabitation Relationship Violence Ordinance, which may contain a provision requiring abuser to attend mandatory programs so as to change the abuser's attitude and behavior of molesting his or her spouse, former spouse, relatives, cohabitant, or former habitants. Madam Chairperson, please rest assured we will continue with our efforts to combat domestic violence. Thank you.
Madam Chairperson, we are done for the response. Thank you.
Thank you very much, Mr. Tang, and thank you for remaining within the time limits so that we can move now, dear colleagues and delegation, to the questions for today regarding questions 10 to 19 of the list of issues. I will give the floor to my colleagues, and I understand that some of my colleagues will also be requesting, asking some follow-up questions from things we have heard from yesterday. So the first speaker on my list is Mr. Bulkan. Sir, you have the floor.
Thank you, Madam Chair. Good morning, colleagues, and very good afternoon to members of the delegation. Thank you very much for your answers yesterday and today, and in particular for the very clear structure in which you presented the information, which made it so much easier to follow. And right at the outset, let me say how gratified I am that you've given us the assurance that any proposed Article 23 legislation will follow the requirements of consultation. So I'm sure in conformity with the convention and expectations of civil society, that consultation will be widespread, meaningful, and the results reflected in the ultimate draft bill. So thank you very much for that. Just some quick clarification, though, of some other points. In particular, I didn't get an answer to the question, which remains very important for us, where enforcement of the NSL by law enforcement from the mainland results in violations of fundamental rights, or let's say alleged violations even of rights, protection against torture, for instance, or arbitrary arrest. What remedy exists for residents of of Hong Kong who are caught up or who are subject to such violations? Where can they seek legal redress? Thank you for your clarification this morning of your position on the NHRI. But may I just refer to my comments yesterday, and as given the examples that we provided, any NHRI would be, I would say, necessary because and not duplicate, because there is, as you just said, no, the EOC is not an NHRI. There are these piecemeal bodies, and as my example said, they lack effective powers, and they're arguably not independent, as demonstrated from the lack of status given to the EOC under the Paris Principles. So again, I would repeat my question whether the Hong Kong government would consider a comprehensive NHRI with a comprehensive mandate, effective powers, and sufficient independence. Finally, could you please clarify for us, as I asked yesterday, especially given your assurances that Article 39 obligations will be respected, could you please assure us that NGOs participating in this periodic review will not be charged under the NSL or subject to any other victimization for their participation? So I turn now to today's questions, and I will deal with issue 10 on the right to life and protection against torture. I thank you for the answers that you provided to this issue in the replies that we received. Unfortunately, however, publicly available information contradicts the replies and indicates that the Hong Kong police force has consistently violated UN principles on the use of force and international human rights standards, including those contained in our General Comment 37 in the course of its response to public protests. Because of the wide discretion on the part of law enforcement to characterize assemblies as riots, thereby engaging riot control agents and enhance methods in response, those responses have frequently been excessive, involving the indiscriminate use of less lethal weapons and the use of chemical substances past their expiry date, actions which result in serious injuries, not just against demonstrators, but also against bystanders, commuters, journalists. Please explain how such responses are consistent with UN guidelines on the use of force and international human rights standards. Will the Hong Kong government commit to ensuring that force is resorted to only where necessary and no other means are available, and especially so in the case of lethal force? I note your reply that the police response to the siege at City University of Hong Kong was conducted to disperse so-called rioters. However, the commander-in-chief of the riot police was recorded by the media instructing his subordinates to aim for and shoot at protesters' heads. This evidences a disregard for human life and safety and violates not just human rights principles, but basic common law standards regarding the proportionate use of defensive action. Kindly explain the justification for such police methods. How can they be reconciled with your repeated assurances that Article 39 of the Basic Law, which applies the ICCPR throughout the SAR, continues to be respected? Crucially, can you tell us whether such an instruction to shoot at the heads of protesters constitute lawful authority for subordinate officers as stipulated in Section 3(4) of the Crimes Torture Ordinance? Finally, I wish to refer to your information in the 4th periodic report that the non-derogable character of the prohibition of torture is clearly provided for in Section 5(2)(c) of the Hong Kong Bill of Rights Ordinance, and that this has been recognized by the courts in various rulings. Could you please provide us with examples of those court rulings in which this non-derogable character of the prohibition of torture has in fact been recognized? Thank you very much, and I look forward to your replies. Thank you, Madam Chair.
Thank you, Mr. Bulkin. The next speaker I have on my list is Mr. Gomez. Mr. Gomez.
Gracias, señora presidenta.
Thank you, Chair, and good morning, everyone. And I would like to thank the delegation of Hong Kong, China for the answers they have provided. Now, that said, and referring to the question that I had about violence against women, I believe that no specific data has been provided. The information that we were asking for, the very information that would allow us ultimately to draft a concluding observation that would be useful for all, which is why perhaps that information can be submitted in writing within the 46 hours following the conclusion of this constructive dialogue. Today, I will be asking questions on 3 issues of the list of issues, namely 11, 12, and 17. The first one, on 11, refers to the prohibition of torture and other cruel, inhumane, or degrading treatment or punishment. In its response to this question, Hong Kong, China provides details on the functioning of the Complaints Against Police Office, as well as the Independent Police Complaints Council. But it fails to address the main concern expressed by the committee in its previous concluding observation, namely in paragraph 12, in which we concluded that Hong Kong, China should take the necessary steps to establish a fully independent mechanism to conduct proper independent investigations into abuses of power by the police. Could the delegation inform the committee on the steps taken to implement this recommendation? On 19 November 2020, the Court of First Instance ruled in a judicial review that the existing complaints mechanism involving the complaints against the police office, with oversight by the Independent Police Complaints Council, is inadequate to discharge the Hong Kong, China's government obligation to establish and maintain an independent mechanism capable of conducting effective investigation into complaints of suspected ill treatment by police officers. Could the delegation inform the committee about any steps taken in order to follow this judicial decision? Could the delegation also provide information on whether the number of complaints presented to the Police Complaints Office or the Independent Police Complaints Council about ill treatment by the police has increased since the entry into force of the National Security Law on 30 June 2020? Hong Kong, China also fails to report on complaints that have resulted in a formal charge before the courts or in a conviction. Hong Kong, China's response reports that the police periodically reviews its guidelines and orders on the use of force to bring their actions in line with the principles of proportionality and necessity. Can the delegation report on the content of these reviews and on any new regulations, protocols, or guidelines that may have been issued? Can the delegation report on whether the UN Basic Principles on the Use of Force and Firearms by law enforcement officials adopted in Havana in 1990 have been taken into account in these reviews? Does Hong Kong, China envision establishing compulsory recording of sound and image of all police interrogations as a means of both accurately recording the content of the statement and preventing police abuse? And this brings me now to issue 12, which relates to the death of persons deprived of their liberty. In its report, Hong Kong, China informs about 126 deaths in the prison system from 2011 to 2019. In light of this information, the committee would like to ask the following questions to the delegation. First, can it provide data on deaths in the prison system updated as to this date of the present constructive dialogue? 2, can the delegation provide disaggregated data on the cause of these deaths as established and determined by the authorities? Third, according to the delegation, are there any factors in the prison system, such as possible pressure from the inmates themselves or potential poor conditions of detention that may have contributed to these deaths? 4. Has there been any increase in these deaths since the entry into force of the National Security Law on June 30, 2020? Hong Kong, China provides figures on complaints filed with the Department of Correctional Services about ill treatment or torture of persons deprived of their liberty, unnecessary use of force, and abuse of authority. Could the delegation provide disaggregated data on complaints that have resulted in a formal accusation before courts or a conviction? People that have been lodged in a penitentiary establishment, do they have access to a judge that would determine what their rights are within that penitentiary system in the area of, for example, exit permits or penitentiary treatments? And lastly, I will be speaking about question or issue 17, which relates to the independence of the judiciary, access to justice, and the right to a fair trial. According to Article 44 of the National Security Law, national security offenses have to be handled by designated judges. The chief executive should designate judges from incumbent magistrates and judges from each level of the court system to handle national security offense cases. Prior to granting the designation, the chief executive may consult the chief justice and the Committee for Safeguarding National Security. The direct appointment of judges by the executive, taking into account that consultation with the Chief Justice is not compulsory nor binding, might not be respectful or in keeping with judicial independence. Moreover, the potential consultation of the Committee for Safeguarding National Security seems inappropriate in maintaining judicial independence. And what's even more, the Chief Executive is required by the law not to grant the designation to those who have, quote, made any statements or behaved in any manner endangering national security, unquote, which reveals a risk of ideological bias in those judges who are finally appointed. Another aspect of the specific statute of these judges designated for handling national security offenses that can pose some problems is that their appointment can be withdrawn if a designated judge makes any statement or acts in any way that is considered endangering national security, which again opens the field for the government ensuring a specific ideology in its judges. And additionally, it undermines the security of tenure of judges, which is a precondition of their independence.
And finally, the fact that the complete list of designated judges is not made available to the public, using the pretext that the government believes that such a revelation of the complete list would pose security threats to the designated judges, is a practice that reveals a lack of transparency being so necessary for public trust in justice. Could the delegation of Hong Kong, China inform the committee as to the number of judges designated under the national security law, and also provide us with information as to how many of them have been withdrawn from office? In 2021, 2 senior British judges who fulfilled their functions in Hong Kong resigned. In their statement delivered on the occasion of their resignation, said judges specifically mentioned their view that the national security law has proven to be a serious obstacle to the implementation of the standards of due process of law. How do you assess this resignation, and what is your reaction to this statement by the judges as a delegation? In handling national security cases, the department responsible for safeguarding national security can enact those measures provided for in the national security law. Could the delegation clarify whether those measures can be adopted and enacted solely on the authorization of the chief executive and without judicial review being necessary before they are enacted or used? According to information we have received, 74.3% of defendants charged with national security crimes were denied bail. And once bail is denied, pre-trial detention can become a form of indefinite detention. And very often the decision on this issue, the decision to deny bail, is not taken on the basis of proper and substantiated judicial reasoning. For the several dozen politicians and activists charged with subversion on February 28, 2021, pre-trial detention has already lasted for well over a year. It has also come to our attention that the decision to refuse bail in the many cases I referred to above is based on facts attributed to the accused, facts that the accused are said to have engaged in prior to the National Security Act coming into force, which would imply giving the act retroactive effect. Can the delegation comment on this information and these reports? The national security law allows for certain trials to be heard in camera or behind closed doors, and it also allows for the denial of the right to be tried by a jury. Could the delegation inform the committee on the number of cases tried in these specific manners, i.e. behind closed doors and or with the right to be tried by jury denied, and the criteria for following said procedural adjustments? In its replies, Hong Kong China informs the committee that the government has no intention of establishing an independent legal aid authority. If such is the case, could the delegation inform the committee about steps taken to overcome the long-standing gap that, according to sources, exists in Hong Kong, the gap that is between the available legal services and the community's needs for timely, accessible and affordable legal assistance that would be in full compliance with Article 35 of the Basic Law? We have received information which seems to indicate that targeting and intimidation of lawyers in Hong Kong, China, whose practices include bringing judicial review suits or who have represented opposition figures and protesters, is occurring. We have, for example, the case of barrister and human rights defender Chow Hang-tung, who is now herself a defendant under the national security law, accused of violating said law. Could the delegation provide information on this issue, and in particular could provide us with information on the procedure followed in taking legal action against Ms. Chow Hang-tung? According to our sources, some defendants in proceedings that have been opened under the national security law have waived their procedural rights by being appointed legal, or rather their procedural rights have been waived for them because legal aid counsel has been appointed on their behalf, legal aid counsel that is linked to the Hong Kong China government and mainland Chinese officials. In January 2022, Mr. Tong Yin-kit abandoned his appeal of a 9-year criminal sentence for terrorism and inciting secession under the national security law. Although Mr. Tong has not spoken publicly about his case, many observers believe that his decision to drop his appeal was directly linked to the move by the Legal Aid Department to assign new lawyers to him in November of 2021. One of the lawyers assigned to Ms. Tong's case worked for a firm with strong ties to both the Hong Kong government and to mainland officials. Can the delegation please comment on this case of Mr. Tong Yin-kit? Finally, on this issue, according to Article 47 of the National Security Law, the courts of the Hong Kong Special Administrative Region need to obtain a certificate from the Chief Executive in order to certify whether an act involves national security or whether the relevant evidence being brought in a given trial involves state secrets when such questions arise in the adjudication of a case. So they need that ruling, that input from the chief executive before they can take a decision. The certificate shall then be binding on the courts. Could the delegation explain how this provision is compatible with the independence of the judiciary and the principle of the separation of powers? Thank you very much for your kind attention, and I'm looking forward to your responses.
Thank you very much, Mr. Gomez. Next speaker on my list is Ms. Abdurrashol. You have the floor, madam.
Thank you very much indeed, Chair. I'd like to bid the delegation welcome. It is my hope that this dialogue will take place in a spirit of good understanding, and in the understanding that the overall aim of this dialogue is to ensure the full implementation of the ICCPR in Hong Kong, China. I will be focusing on issues 13 and 14, treatment of foreigners, including migrants, refugees and asylum seekers. The committee is concerned that Hong Kong does not have an appropriate legal framework governing the granting of asylum and the protection of refugees. As an upshot of this, asylum seekers are subject to domestic immigration laws, and this places them in a position of extreme vulnerability. Hong Kong, China currently adopts a unified screening mechanism in which the Immigration Department and the Torture Complaints Board review applications for protection from expulsion, refoulement, or extradition in a procedure that only assesses non-refoulement. and which results in protection being granted on purely humanitarian grounds, which does in no way regularize the immigration status of these categories of persons. These persons are, as a result, prohibited from working, even when they have corroborated applications and even when they're in Hong Kong under refugee status, except in some cases where the Immigration Department exercises discretionary powers to grant a work permit valid for 6 months, subject or with the option of renewal. The committee is aware that a legal challenge to this procedure, to the situation before the Court of Appeals went ahead, but that it was unsuccessful. Not being entitled to work, applicants are entirely dependent on the government's humanitarian assistance program. But according to the information received, the level of coverage available to them under said program does not meet basic needs. In light of the aforementioned, the delegation is requested to provide details on the process that is followed for granting an alternative immigration status to refugees in order to allow them to remain legally in Hong Kong, China until the end of the process and to facilitate their access to legal work. Is it possible for the Immigration Department to exercise more discretion in the processing of work permits? Could the delegation also please provide statistics on the number of applications for legal aid and the number of persons benefiting from this assistance for non-refoulement cases since 2014? The committee has received information on the government's refusal to publish redacted versions of the decisions of the Torture Complaints Board. Could the delegation provide us with information in response to these allegations? Could I also ask whether there is any redress mechanism for asylum seekers' claims? Under current law, children of asylum seekers born in Hong Kong, China, have no right of residence, nor do they have the right to work when they grow up. In some cases, they are denied tertiary education. In light of the above, may I ask what measures are being taken or considered to safeguard the right of these children, in particular when it comes to their access to tertiary education? If such assistance is currently being provided, please could you provide us with data disaggregated by country of origin, gender, length of stay in Hong Kong, age of the applicant, and the type of assistance they're receiving? Between 2014 and 2020, of the 17,618 non-refoulement applications, the Immigration Department only considered 179 of them to be substantiated, which only equates to 1%. Hong Kong continues to detain non-refoulement asylum seekers, and by November 2018, the number of persons detained in such manner stood at 381 individuals approximately. Could you provide us with updated numbers, given that the most recent number we have dates back to 2020 and 2018 respectively? Hong Kong, China did not provide a specific response to the question asking the list of issues regarding immigration detention and procedural safeguards for claimants against arbitrary detention of foreigners as provided for in the Immigration Ordinance, including any measures on judicial oversight and protection of persons in vulnerable situations. On this particular point, Hong Kong indicates in its response to the list of issues in paragraph 81 that the Immigration Ordinance empowers the Immigration Department to detain a person pending removal and during the assessment of the application for non-refoulement. The committee has previously expressed its concern that the Immigration Department already has overly broad powers to detain applicants on protection issues and protection consideration cases, and amendments made to the Immigration Ordinance have expanded these powers yet further by providing for more circumstances that can be invoked as justification for the lawfulness of an extended period of detention. And here I'm referring to sections 32(4)A and 37(ZK) of said Immigration Ordinance. As a result of these changes to the immigration ordinance, as I believe will be self-evident, detentions increased. By May 2021, the Tai Tam Gap Correctional Facility had been converted into a detention center with 1/3 of places in the correctional facility set aside for immigrants. Said situation clearly runs counter to the principle established in international human rights law, according to which immigration detention should be applied solely as an exceptional measure of last resort. It should be applied for the shortest possible period of time, and it should be applied only if justified by a legitimate purpose. According to information we have received, limited procedural safeguards, and the safeguards are very limited in my view, such as a bail application process or an independent review mechanism, are available to review cases of immigration detainees. Limited judicial oversight is available through habeas corpus only. And there was no successful application in the immigration context under these safeguards because detainees have limited access to legal counsel and representation. Given this scenario, could the delegation indicate whether Hong Kong is considering alternative options to detention for asylum seekers and protection seekers? Those who are seeking protection of their rights under this heading. And could the delegation share with us any steps it has taken or intends to take to bring the amended immigration ordinance and its overall immigration policy in line with international humanitarian and human rights standards, and in particular, the provisions of the International Covenant on Civil and Political Rights? Could the delegation indicate what measures Hong Kong China has taken to provide procedural safeguards to those who have filed a petition against against arbitrary detention? Can the delegation confirm the allegations that since January the 11th, 2019, the Immigration Department stopped keeping statistics on individual periods of detention? Should these allegations not be true and said statistics be available, the committee would be grateful to receive them. As I said earlier, we have a concern about these periods of detention because they seem to us to be overly long, and there seems to be a trend to make overly broad use of them. Furthermore, are there any plans to ratify the 1951 Convention relating to the status of refugees and its 1967 protocol? Finally, although Hong Kong has ratified the 1954 Convention relating to the status of stateless persons, it has not ratified the 1961 Convention on the reduction of statelessness. In this regard, may I ask the delegation whether they do indeed plan to ratify the 1961 Convention? I'd like to thank you in advance for your answers to my questions. Thank you.
Thank you very much, Ms. Abdurrashol. The next speaker on my list is Mr. Furuya. Mr. Furuya.
Thank you, Madam Chairperson. Good afternoon to the members of the delegation in Hong Kong, and good morning to the members in this room with us. Today, I will address the issues in paragraph 15 and 16. However, before going to these issues, please allow me to raise one follow-up question on the reply the delegation made yesterday. First, I thank very much the delegation for having answered my question concerning the implementation rules under Article 43 of the National Security Law. So according to the delegation's explanation, the measures under National Security Law and implementation rules are taken with the procedural safeguards which are consistent with the international standard. However, as I pointed out yesterday, implementation rules allow the police to act without a court warrant to search the homes of national security law suspects, to tap their phones, to freeze their assets, and to censor online speech related to alleged crimes. Actually, the committee received many allegations that the police has taken such measures arbitrarily for the purpose of dampening of free speech and crack down on pro-democratic peaceful movements. Please explain what measures the Hong Kong government has taken to prevent such abusive uses of power by police and implementation rules under the implementation rules, and also indicate how the safeguards the delegation mentioned yesterday are working in practice, not on paper. Now I turn to today's issue in paragraph 15 regarding trafficking in persons. From the report and reply, the committee acknowledged that Hong Kong government has been taking various measures to tackle with the issues of trafficking in person. Particularly, according to the reply, between 2017 and 2019, nearly 20,000 initial victim screening were conducted. In relation to the screening, I have the following questions. First, what is the definition of victim for these screening measures? The Hong Kong Bill of Rights Ordinance prohibits slavery and slave trade, servitude and forced labor, but it does not explicitly prohibit human trafficking for the purpose of exploitation. China is a state party to the Palermo Protocol to prevent, suppress, and punish trafficking in persons. However, it is not applied to Hong Kong. Please indicate whether the definition under the Palermo Protocol is also available to all relevant laws applied to Hong Kong and in its practices. The reply stated that by the screening between 2017 and 19, only 30 victims were identified, and then the small number and percentage of victims reinforce the observation that trafficking in person has never been a prevalent problem in Hong Kong. In my view, however, the small number of victims found does not necessarily indicate that actual victims are really small in number, because it is depending on the definition and procedure. This concern brings me to the second question. The report described that the police and the immigration department put in place an enhanced mechanism for victim screening and identification in 2016. Under the mechanism, the officers conduct a two-tier screening on persons who are arrested or who put themselves forward to the authorities. Please provide information on what concrete procedure is taken to ascertain whether they are victim or not, and also indicate the measures which has been taken to improve the screening mechanism to identify victims of trafficking more effectively. Now I move on to the paragraph 16 concerning the protection of migrant workers. According to the reply, the Employment Amendment Ordinance 2018 raised the maximum penalty for the offenses of employment agencies overcharging job seekers and unlicensed operation. However, report only indicate that 119 employers of foreign domestic helpers were convicted between July 2010 and July 2017. Please provide an updated number of offenses committed by employment agencies, including investigations, prosecutions, convictions, and sentences handed down, as well as the remedies provided to the domestic migrant workers. In the previous concluding observations, the committee recommended to repeal the so-called 2 weeks rule, which stipulates that migrant domestic workers must find new employment or leave Hong Kong within 2 weeks after the employment contract ends. The problem of this rule is that it would discourage migrant domestic workers from reporting illegal employment due to the fear that they would lose their job and have to leave Hong Kong. In this regard, it is quite important to ensure that even a job ends because of his or her reporting of illegal employment, he or she can continue to stay Hong Kong and find another employment as a domestic worker. According to the annex to the report, Immigration Department may consider granting exceptional approval for migrant domestic workers to change employers when there is evidence suggesting that they are being exploited or abused by their employers. The report said that as of November 2019, the change of employer after premature termination has been approved in 6,478 cases. However, these cases include not only the case where the worker has been abused, but also the employer's external transfer, death, or financial difficulty. Please provide information on the number of applications for changing employers and approve the case because of the exploitation. In addition, please explain whether Hong Kong government is willing to make such an approval a rule, not an exception, and adopt a new policy to repeal two-week rule partially only for the workers who have reported the exploitation and has to change their job before the employment contract ends. Madam Chairperson, this ends my question. I'm looking forward to the fruitful discussion and dialogue with the State Party. Thank you very much.
Thank you very much, Mr. Furuya. And I see the final speaker on my list is Ms. Sansin. Madam, you have the floor.
Thank you very much, Madam Chair, and good afternoon to the members of the delegation in Hong Kong, China, and those members of the mission with us here in the room. I wish to start with some quick follow-up questions to my yesterday expressed concerns. In particular, I asked you whether there is any possibility to review the constitutionality of the national security law. And I'm particularly interested that in light of the conclusion of the court in the case of Hong Kong versus Lai Chi-ying, where in paragraph 70, this is the case of 2021, it said that the legislative acts of the promulgative acts under the national security law basically are not reviewable under the constitutional review by the court, because even if any alleged incompatibility between the national security law and the basic law or our covenant as applied to Hong Kong exists. So the court says no constitutional review is available. So I'm wondering whether there is anything else that you could provide us with that would dispel these doubts as to the compatibility of this understanding with the obligations under the covenant. Now, let me express my regret that to my questions under issues 7 and 8, I have basically not received anything new to what has already been provided in the report or in the replies submitted by Hong Kong, China. And I particularly would like to know whether there are any developments underway towards the adoption of the comprehensive anti-discrimination legislation. And I would also like to repeat my request for any statistics under the existing discrimination ordinances, all 4 of them, particularly for the last 2 years, because this is a relevant period that we are looking into, since it is a period after the adoption of the national security law. And I also would like to once again ask you whether there have been any efforts undertaken to sensitivize the general public towards the issue of the LGBTI and especially also transgender persons, because we have received reports of hate crime, hate speech against these individuals, and you have told us that this is a sensitive issue. Nevertheless, were there any awareness raising campaigns conducted or any other activities undertaken to sensitivize the general public? And now let me turn to my questions of today, which are covered by issues 18 and 19 and concern the right to privacy under our covenant. First, I appreciate the information provided in the replies that the Code of Practice issued pursuant to Section 63 of the Interception of Communications and Surveillance Amendment Ordinance provides guidance and also some illustrative examples to officers in relation to conditions for authorization for interception of communications and surveillance and oversight procedures. I also noted that in this code of practice, section H, which deals with ensuring compliance, envisages disciplinary sections and prosecutions for common law offenses for conduct of officers that is not in conformity with this ordinance. So could the delegation please provide us with the information on how many of such disciplinary sanctions or any procedures for offenses were started since the entry into force of this ordinance, and what were the results of these procedures? I also wish to note that there exists a certain overlap of authorization, the ISCO, and Article 43 of the National Security Law, which also provides for carrying out interception of communications and conducting covert surveillance on a person who is suspected on reasonable grounds of having being involved in the commission of an offense and endangering national security upon approval of chief executive. So could the delegation please clarify if the ICSO overrides Articles 29 and 30 of the Basic Law, which provides for protection from arbitrary intrusion into privacy, and also what are the elements for constituting public security, which is an exception provided under Article 30 of the Basic Law. I'd also like the delegation to please clarify whether a situation such as a global pandemic comes under the ambit of a public security as provided in Article 3 of the ICSO. And further, does the interception and surveillance for COVID-19 purposes come under type 2 surveillance or emergency surveillance? I would also very much appreciate the data on how many authorizations for type 2 surveillance were carried out during COVID-19 and number of requests for executive authorizations approved under Division 3, emergency authorization under Division 4, and judicial authorization under Division 2 of the ISCO until the present day. I also know that under Article 53 of the ICSO, the Commissioner may require any public officer or any other person to answer any question and to provide any information, document, or other matter in his possession or control to the Commissioner. Could the delegation please explain the compatibility of this provision with Article 17 of the Covenant and our general comment number 16? More so, could the delegation please clarify the procedure of special provisions for oral application under Division 5 and authorization under said application, which is not requiring any affidavit or statement under Article 25, paragraph 3 of the ICSO. I also note that Stay Home Safe app, which was government mandated under the Health Ministry requirements, requires any inbound traveler to Hong Kong to download this app, while residents are also expected to download the government tracing app Leave Home Safe, which allegedly requires far more than normal access for a contact tracing app based on QR code scanning, including read the contents of your USB storage, modify or delete the contents of your USB storage, view network connections, and full network access. So could the delegation please explain who can access the data collected by these apps and under what procedures? And could the delegation also comment on concerning reports of unrestricted school surveillance and interception of data of trade unions in Hong Kong, China? Moving to issue 19, I thank the delegation for providing us with information on measures undertaken to strengthen the protection of personal data by public authorities, including the Registration and Electoral Office, and also statistics till July 2020 on complaints that were brought to the Office for the Privacy Commissioner for Personal Data. Could the delegation, however, provide us with the update on these statistics, particularly for the last 2 years? I know that in 2021, the amendments were adopted aimed to combat doxing acts that are intrusive to personal data privacy through decriminalization of doxing acts and conferring on the Privacy Commissioner for Personal Data statutory powers to issue cessation notices demanding the cessation or restriction of disclosure of doxing content. Could the delegation, however, please comment on concerns that this amendment ordinance can be seen as a move to curb freedom of speech and expression on social media and a way to influence social media platforms in contravention with the Covenant and the Basic Law? Also, the Hong Kong's Office of the Privacy Commissioner for Personal Data announced it removed 90% of social media posts that reportedly contained docs information, and you issued 774 cessation notices between October of 2021 and May of this year. So there were some people also arrested. Could the delegation please explain what is the criteria for sending out such cessation notices to social media companies? And could the delegation please comment on the concerning reports that some detention facilities have been transformed into the so-called smart prisons, where detainees are surveilled even in most intimate spaces, such as, for example, toilets? Finally, could the delegation please clarify why it was not reasonably practicable to obtain a warrant by police officers who have accessed private data on smartphones of persons arrested during the protest against the extradition bill? And how was it ensured that these searches were limited to what was directly and immediately relevant to the offenses which were the subjects of arrest? So, why was it reasonably unpracticable to obtain arrest warrants, and how the searches were limited? I very much thank in advance the delegation for any answers provided to these concerns, and I thank you, Madam Chair, for the floor.
Thank you very much, Ms. Hansen and colleagues. I would like now to suspend for 10 minutes. I see 11:05 here, 11:06. So we will suspend and break from the platform for 10 minutes in order for the delegation in Hong Kong to prepare its responses. And when we resume, the delegation will have the floor to give the responses to the questions raised by my colleagues. So the meeting is suspended for 10 minutes. So we resume this session, and I will immediately give the floor to the delegation in Hong Kong, asking Mr. Tang to take the floor and then organize the responses of the delegation in any way he wishes. So, Mr. Tang, sir, over to you.
Members have raised. Okay. Madam Chairperson, well, I'm sure you've noticed that members have raised quite a large number of questions involving various of subjects and policies. Well, I appreciate very much, which shows that members are very concerned about Hong Kong's situation. But I just hope you understand that we do need some sufficient time to give some meaningful responses. So we'll try, but I'm not sure whether we can finish it within the time as scheduled. So let's do our best. Well, since most of the questions are within the ambit of our Security Bureau and Police, I'll give the floor to Mr. Zhou Chao of the Police, and then our Security Bureau's colleagues. Please.
Thank you, Madam Chair. I'd like to respond to the comments made earlier in relation to use of force in 2019. Between June 2019 and early 2020, Hong Kong had been haunted by a prolonged period of social disorder and violence, the level and extensiveness of which were extremely alarming. And all these illegal acts had endangered public safety and public order and greatly affected the daily lives of ordinary citizens. There were also many groundless and malicious accusations against the police at the time. For instance, a female alleged being raped inside a police station in October 2019, and her allegation was found to be inconsistent with the evidence upon investigation. There was also a case where a man alleged that a serial rape of female protesters were committed inside the holding center, which was later also found to be untrue, and the man was prosecuted and sentenced to imprisonment. While certain media reports accused the police of using excessive force in certain scenarios, they rarely mentioned the extreme violence inflicted by the rioters. Before that one snapshot of what appears to be excessive, it was regrettable that many media and online reports used short and edited video that were taken out of context and failed to give a fair and balanced account. Inappropriate and untruthful information not only confuses the public, but also purposefully divides the society, incites hatred, provokes discontent, and compromises public order and national security. The turmoil in 2019 was fueled by lies and rumors and anarchism hidden under the name of democracy. As you might not be made aware of, therefore, I like to provide some factual information to your good selves. Rioters heard over 5,000 petrol bombs, and the police seized over 10,000 petrol bombs. Large quantities of explosives like TATP, HMTD, RCIED that were commonly used in terrorist attacks, and related precursor chemicals, as well as 6 genuine firearms with very large quantity of ammunition were seized. Over 22,000 square meters of paving blocks of footpaths were illegally removed for the purpose of hurling at targets. Some 60 kilometers of railings were dismantled. Around 700 traffic lights, 1,500 traffic bollards, and 100 traffic signs were damaged. Over 90% of our rail and subway stations were paralyzed by destruction. Numerous shops and restaurants which rioters deemed unsupportive of their views were vandalized. Protesters used highly deadly weapons, including bricks, slingshots, metal rods, metal pellets, arrows and bolts, modified air gun, corrosive substance, not to mention explosives and genuine firearms that we have seized. Worse still, these rioters even set fire on a 57-year-old man because he held an opposing view, and killed a 70-year-old cleaner with bricks simply because he had the audacity to video them. Except for the damages and seizures of weapons mentioned, there were over 2,800 casualties reported, among which over 600 were police officers. Judging from the above facts, one should know that the demonstration at the time was definitely not peaceful, as falsely claimed and reported by some media. We, police, are under a statutory duty to take lawful measures to maintain public order and public safety. When illegal and violent acts occur, we are duty-bound to take appropriate actions in order to maintain law and order, protect lives, and safeguard public safety. Same for all places around the world. If demonstrators express their views in a peaceful and lawful manner, there's no need for us to use any force at all. The actions by the Hong Kong police are responsive, but not abusive. We have stringent guidelines on the use of force that are consistent with the international human rights norms and standards. We are extremely restrained in the use of force, and we only use the minimum necessary force to achieve a lawful purpose. According to our internal guidelines, the level of force must be proportionate, reasonable, and responsive to the threat facing the officer. Once the purpose is achieved, the use of force will cease, and every officer is accountable for the force used. I'd like to emphasize that throughout the 2019 social unrest, not a single protester was killed during our enforcement, even under such a serious violent situation. And this is the example showcasing the professional work of my staff. To conclude, the 2019 serious violence is unprecedented to our history. The Hong Kong police force, as the first and final resort of our city, stood fast and defended the line between chaos and order, lawful and evil, good and bad. If someone breaks the law, we as police officers have no choice but to stop and arrest them. I also like to provide some information in relation to the queries made yesterday on the use of chemical agents and also the display of call signs. I will quickly go through that. Across the world, chemical agents are widely used by law enforcement agencies to handle riots and disperse violent protesters. The Hong Kong police are not the only law enforcement agency to do so. The primary objective of using chemical agents is to create a safe distance between police officers and protesters so as to avoid close confrontation and to reduce the chance of injury to both parties as far as practicable, while dispersing the crowd and controlling the violent scenes. The police has conducted a review of experience of overseas law enforcement agencies and noted that tear gas as part of the chemical agent remains one of the most common riot control agents extensively used by overseas law enforcement agencies to disperse crowds during protests and quell the riots. And after extensive review, we have concluded that the source of public concerns over the use of irritant devices in Hong Kong was highly fueled by fake news and biased reports with no scientific principles, facts, or conclusive research to justify the contention. In fact, literature review and studies of expert opinions provide no indication that tear gas would present health issues or environmental problems. And I have to reiterate that the reports against the use of tear gas by Hong Kong police are not referred to the actual circumstances at the scene, in particular the extremely violent acts committed by rioters. And minimum necessary force, including tear gas, had to be used during police operation in order to restore public order and public safety. Finally, in relation to the display of call signs, actually the independent judicial system of Hong Kong is currently handling a judicial review of the constitutionality of the police identification system. As the judicial proceedings are ongoing, it will not be appropriate to comment on this specific case. However, there are some fundamental principles that should be highlighted to put matters into context. On the display of identification, the police have put in place guidelines governing the wearing of uniform and production of warrant cards. In general, uniformed police officers on duty would display their unique identification numbers and the badges of rank if appropriate, and they should produce their warrant cards upon request, except when circumstances do not allow, or to do so would prejudice the police action and or the safety of the officers concerned, or the request is found unreasonable. When plainclothes police officers deal with public and exercise police powers, they will identify themselves and produce warrant cards. Throughout the 2019 serious violence, the police introduced operational call sign cards as an alternate means. Although the use of operational call sign cards have been suspended pending the outcome of judicial proceedings, the police maintains that it was a robust, necessary, and practical system implemented to enhance operational efficiency, maintain a means of identification, and to protect officers from doxing at scenes of serious public disorder. In the judicial proceedings held in our court of first instance, the court recognized that doxing was a serious situation in Hong Kong, and the risk posed by doxing were real and substantial. Police officers and their family members whom had been doxed were personally affected by misuse of personal data, telephone nuisance, fraudulent loan applications or purchases, unlawful disclosure of the personal data on public domains, and receiving threats of personal harm, etc. As at the end of last month, this year, a total of 2,704 police officers, alongside 1,185 connected persons, such as family members, have been maliciously doxed since June 2019. Despite the existence of court injunction orders against the doxing of police and judicial officers, malicious doxing activities continue to pose serious threats to society to this very day. I here conclude my part and I pass it to my colleague. Thank you, Madam Chair.
Thank you, Madam Chair, and thank you, members, for raising questions regarding issues under the Security Bureau. First, some members have raised questions on asylum seekers and project claimants. I'd like to highlight that the Hong Kong SAR government has put in place a unified screening mechanism to screen non-refoulement claimants. The procedures, which are established following court decisions, meet the highest standards of fairness and compare most favorably with those adopted in other common law jurisdictions. The mechanism ensures that claimants would have every reasonable opportunity to substantiate their claims with sufficient protection safeguards. Each claimant is provided with properly funded legal assistance and professional interpretation services. Claimants aggrieved by Immigration Department's decision may lodge an appeal without any merits test, and the appeals are considered by an independent torture claim appeals board, whose members are mostly retired judges or magistrates or overseas experts. In addition, they can also apply to the court for judicial review. Whether a claim is substantiated or not depends entirely on the particular facts and merits of the case. From March 2014 up to the end of April this year, over 20,000 claims have been processed under the mechanism, but only about 1.25% are substantiated. The very low substantiation rate reflects that most claimants in Hong Kong do not have sufficient justification to substantiate their claims. And I also like to stress that these non-refoulement claimants are illegal immigrants, overstayers, and persons refused permission to land upon arrival. They do not have any lawful status to stay in Hong Kong. A child whose parents are non-refoulement claimants cannot obtain permanent status in Hong Kong. And also the Immigration Department is empowered under the law to detain any immigration offenders during the various stages of screening and or removal process. Our government has formulated our immigration detention policy in accordance with the relevant legal principles established by the court, which is published online for public access. The department would, on a case-by-case basis, determine whether an individual should be detained, taking into account the relevant factors and circumstances of the case, including whether that person has committed a serious crime, whether that person is likely to pose a threat to the community, and also whether there is any risk of that person absconding or reoffending. So there's no arbitrary detention at all. The duration of detention depends on the circumstances of each case, and hence cannot be generalized. The Immigration Department conducts regular and timely review of each detention case to determine whether an individual should be further detained, and would notify that person in writing the results with justifications. Any detainee dissatisfied with the detention decision has a right to access to the court. At present, among the 14,800 claimants still staying in Hong Kong, only about 300 of them, that is about 2%, are detained pending removal or final determination of the claims. Among them, over half of them are discharged prisoners who have previously committed serious crimes such as trafficking in dangerous drugs, burglary, and robbery. I also like to add that unless the person has the right of a boat or right to land in Hong Kong, he or she requires an entry visa or permit in order to work here. Our Court of Final Appeal has also upheld in 2014 that substantiated claimants and mandated refugees do not have constitutional or other legal rights to work in Hong Kong. Notwithstanding this, the Director of Immigration may exercise his discretion to consider on a case-by-case basis an application for permission to take up employment. Some members have also raised the question of trafficking in persons. First of all, I'd like to emphasize that trafficking in persons is never tolerated in Hong Kong. The government has been making proactive and multi-pronged efforts to combat trafficking in person and to enhance the protection and well-being of foreign domestic helpers in Hong Kong. Although the Parliament protocol is not ratified in Hong Kong, all the TIP conducts already covered by over 50 legal provisions. This established a well-provided legal framework to safeguard the rights. These are comparable to the composite TIP laws in other jurisdictions. Despite our vigorous efforts in victim screening, the percentage and number of TIP victims identified remain low. In the past 2 years, around 14,600 screenings were conducted, with only 4 TIP victims identified. The small number of percentage of victims identified does not reflect any fallacy in our system. Rather, it reflects that TIP has never been a prevalent problem in Hong Kong. Some members have also questioned about the 2 weeks rule in Hong Kong. I'd like to respond that this rule has been implemented since 1987. It is essential for maintaining effective immigration control in Hong Kong, including against illegal employment, and helps prevent foreign domestic helpers from job hopping. The main purpose of this 2-week rule is to allow sufficient time for foreign domestic helpers to prepare for their departure. The existing policy has allowed sufficient flexibility to cater for exceptional circumstances. When there are legitimate reasons, for example, when there was evidence that the foreign domestic helpers have been abused or exploited, they could apply for a change of employment in Hong Kong without first returning to their places of origin. Exploitation of foreign domestic helpers is never tolerated in Hong Kong, and domestic helpers should not feel inhibited from lodging complaints against their employers. Some members have also questions about the police complaint system. To this, I'd like to point out that the 2-tier police complaint system in Hong Kong is a fair, impartial, and effective arrangement which ensures that complaints against members of the police force are handled fairly, effectively, and independently. In fact, countries around the world have set up their own police complaint system based on their needs and actual circumstances. In some places, The complaints are handled by a dedicated unit within the police, while in other places, a two-tier system similar to Hong Kong is adopted. There is actually no single international standard per se. We believe that matters relating to police enforcement action are best handled by the statutory independent police company.
There's a problem with the sound. Ms. Young, we can't hear you. No. Excuse me, to the delegation.
Made by the IPCC based on extensive research and comprehensive internal reviews, and altogether introduced 78 improvement measures to its practice and procedures. IPCC. Right. Since there are some technical error just now, I'd like to repeat the points about the police complaint mechanism. The two-tier police complaint system in Hong Kong is a fair, impartial, and effective arrangement which ensure that the complaints against members of the public are handled fairly, effectively, and independently. In fact, countries around the world have set up their own police complaint system based on their needs and actual circumstances. In some places, complaints are handled by a dedicated unit within the police, and in other places, a two-tier system similar to Hong Kong.
Again, we don't seem to have a sound. We don't seem to have a sound. So please, can I ask the technical services and maybe also inform the delegation that we're not hearing them at this point? Thank you.
Can you hear me?
I think now I can, Ms. Young.
Okay. Sorry about the technical problems just now.
Okay, we can hear you.
Now?
Okay, thank you. Thank you very much.
Okay, maybe I'll start again.
No, you can continue. You can continue. We heard you up to a certain point about the police complaints, so please go.
Okay. In relation to the social unrest in 2019, the IPCC has investigated into the events and published a comprehensive report in May 2020, setting out detailed, objective, and facts-based review on the events, as well as recommendations to improve the police practice and procedures. In May this year, the police has completed follow-up actions on all the 52 recommendations by the IPCC based on extensive research and comprehensive internal reviews, and altogether introduced 78 improvement measures on its practices and procedures. in response to questions relating to the interception of commission and surveillance ordinance. Our members have raised many questions and require many statistics that we will provide later in writing. But I'd like to stress that the Interception of Communication and Surveillance Ordinance provides a stringent statutory framework for regulating the conduct of interception and covert surveillance by law enforcement agencies. Under the ICSO, no public officer shall carry out any interception or covert surveillance unless authorized by a panel judge or a designated authorizing officer. I must stress that all operations under the ICSO must be for the purpose of preventing or detecting serious crimes or protecting public security, and must meet the proportionality and necessity test. An independent commissioner on interception of communications and surveillance, who by law must be a judge or a former judge, has the statutory duty to monitor the implementation of the ICSO requirements. This concludes my remarks today. I'd like to pass it to Mrs. Liu.
Morning, Chairman and members. Members have raised quite a number of questions regarding the national security law. I will try to answer them in the order that they are raised. The first batch of questions are raised by Mr. Balkan as follow-up to what I've explained to members yesterday. First issue, regarding the remedies for violation in case where cases are handled in the mainland, the remedies will be provided as per what is provided for in the mainland law. Regarding the question as to members' participation in exchange with the UN, I should stress that Hong Kong is an international city having close contact and communication with other countries, regions, and relevant international organizations. I should stress that normal interactions and activities are protected by the basic law and the local law of Hong Kong. What the national security law seeks to prevent, suppress, and punish are actually very distinct from normal interactions. Mr. Gomez asked quite a number of members. Can you hear me?
Yes, we can hear you.
Okay. I will continue. Mr. Gomez asked quite a number of questions regarding the appointment of designated judges under the national security law. I should stress that under the basic law, all judges of the Hong Kong SAR enjoy judicial immunity and are appointed by the chief executive in accordance with the legal procedure. The chief executive, as the head of the Hong Kong SAR, is accountable to the Central People's Government, and it is within the purview of the CE to designate a batch of judges from existing judges to hear cases concerning offences endangering national security. Article 44 of the National Security Law stipulates that the CE, Chief Executive, shall designate at different levels a list of judges from existing judges for hearing cases involving offences endangering national security, rather than choosing a particular judge to preside over a specific case. And the CE may consult the Committee for Safeguarding National Security and the Chief Justice before doing so. Article 45 of the National Security Law also stipulates that national security cases within the jurisdiction of the Hong Kong SAR shall be processed in accordance with the laws of Hong Kong. And as such, it will be the judiciary which assigns judges from the list of designated judges to hear the cases, and not the chief executive. The national security law, therefore, has not undermined in any way judicial independence.
We have a break again in sound. Ms. Liu, we can't hear you. Miss Liu, we cannot hear you. I understand that the problem is in the room and not in the platform for those following through the platform, but can Ms. Liu please be informed that we cannot hear her? So just to briefly inform the members in the room that there's a slight technical problem that doesn't regard the platform, but the connectivity, if I understand, from UNOG to here. So while this problem is being resolved, we'll just stop for a while. However, the delegation will be given time. We're asking for an extension as well of the time in order to cover the time lost. This is just to inform my members. Apologies for this this technical problem, but we'll have to wait. Colleagues, I don't know now if the room can hear me. So colleagues, we cannot resolve this issue, and I would like to apologize. It's an issue not of connectivity of the platform. The delegation is there, but it's an issue of connectivity within whatever, what we're using here. UNOG, okay. So what we will do is we will suspend the session at this point, the meeting. We will resume as planned Tuesday morning, where we'll continue where we left off with Ms. Liu, I think, who was giving responses. The delegation will go ahead to give their responses, and then we will turn to the last part of the dialogue. And in the meantime, there will also be extra time allocated. So the delegation and everyone will be informed of the extra time that will be allocated Monday, because Monday, again, was a 2-hour, Tuesday, excuse me, was a 2-hour meeting. But of course, this will be extended, and we will inform the delegation and all those interested accordingly. So at this point, and I'm not sure that the delegation in Hong Kong can hear me, but I would like again to apologize and to say that this meeting is suspended and will resume Tuesday, 10 a.m. Geneva time. Thank you very much for your understanding, colleagues here, and also to the delegation. And we're suspending the meeting.